discuss today. So I think I'm going to start, if that's okay.
Yeah. Okay, I'm going to stop sharing my screen so that everybody else can.
Okay. So good morning, everyone, and welcome to the PLA's first webinar for 2021. I hope you all are doing well and keeping safe. So today is going to be a very interesting discussion. The PLA has invited Graham Demant and Michael Badenhorst to discuss the SCA's 3 recent judgment where the SCA found that Regulation 354 was and is invalid. Graham is a partner at Bowman's and has extensive experience in pension law, amongst other things. Graham will start off by unpacking the SCA case for us and will deal with some of the legal implications, very interesting legal implications. Welcome and thank you, Graham. Michael is an actuary at Cadian Partners and Consultants and Actuaries and has been appointed as evaluator to many retirement funds over the past 17 years that he's been an actuary. Michael will take us through the FSCA's recent Guidance Notice 2 of 2020, which you may be aware that was issued just following the SCA's judgment. And it's that notice where the FSCA had expressed its expectations of boards when dealing with or releasing the assets that backs the liabilities. Welcome and thank you, Michael. So, as some of you may have heard, we will deal with questions right at the end, time permitting. I hope you guys enjoy it. Thank you very much for attending. So over to you, Graham.
Right, morning everybody. Welcome to today. I'm going to talk about the 3 Supreme Court of Appeal decisions which were handed down in relation to Southern Sun, the Vrystaat Municipal Pension Fund and the Hortus Pension Fund. They were heard simultaneously and the judgments were handed down simultaneously. I'm unfortunately going to have to engage in actuarial speak, which for a lawyer is dangerous. It's just about as dangerous as actuaries drafting legislation as well. It is, however, a very fascinating story, so I'm sure you will remain glued to your screens. But in order to tell you the story, I've got to go back in time, probably to a time before some of you weren't even born. So prior to 2001, the Pension Fund Act had absolutely no reference whatsoever to contingency reserve accounts. It doesn't mean that they didn't exist. In fact, what actuaries regularly did was to create contingency reserve accounts. They were there to deal with things that may happen or may not happen. So you were creating a reserve to deal with something where you expected there may be a claim, but you weren't quite sure that there would be a claim. So for instance, a poor data reserve would be a typical contingency reserve that an actuary would create. But the Act said nothing about it. This was the valuator had to deal with it, and he dealt with it as part of his statutory actuarial valuation. Now, it's important that you understand what a contingency reserve is. It is actually on the liability side of the fund's accounts. It is not an asset. You don't actually physically take assets and put them in a reserve account. You create a contingency reserve which you add to your liabilities. And if you want your fund to be fully funded, and of course we all want funds to be fully funded, you will then hold sufficient assets to meet that contingency liability. So in 2001, when the surplus legislation was introduced, a definition of a contingency reserve account was introduced into the Act. And that definition said it's an account that's created to deal with explicit contingencies, so like a poor data reserve, that is created by the board on the advice of the valuator. So it's very important to note that it's the board's power to create the contingency reserve based on the advice of the valuator. Now, a definition means nothing unless you see it in the context, so we then have to understand where does this contingency reserve fit into the Act. Now, the most material aspect was in the definition of actuarial surplus, because we had to know what the actuarial surplus was in order to do the surplus apportionment. So in the definition of actuarial surplus, they said you're going to take the assets of the fund and you're going to weigh those against the liabilities of the fund, and then they said, and the contingency reserves established by the board on the advice of the valuator. So again, you had those words that in establishing the liability for determining an actual surplus, you would add the contingency reserves that had been established by the board on the advice of the valuator. Now, we know that there were subsequent amendments to the definition of contingency reserve, and they were retrospective, and they gave the power to the registrar to disallow a contingency reserve if he felt that it wasn't appropriate. Now, there was also another place in the Act where there was a mention of a contingency reserve. Now, you will all recall that in doing the surplus apportionments, there was a lot of focus on former members who had been former members of the fund back to 1980. And there was a need to identify those former members, and there was a need to top up the benefits that were payable to them. And if you could do the calculation, if you had sufficient data to do a calculation, you had to do the top-up calculation, and that money became due to the former members as part of a surplus apportionment scheme. And that was regardless of whether you could trace those members or not. So for that category of person, you would have somebody you've calculated a value for, but you can't trace, so you can't pay. I'm going to call those untraced former members because they're different to the second category I'm going to talk about. The Act then said that if you couldn't find the data to do the calculation, you had two choices. You could either exclude them from the surplus apportionment scheme, or you could create a contingency reserve. And that is for the poor data former members. So there were two different categories. There was the untraced former members for whom you could do the calculation. And then there was the poor data members for whom you could not do the calculation, but for whom you established a contingency reserve. Now, again, and I've got to read to you because this is an important part of what this case was all about. There was 15 capital B 5E, which said what you did with the money once you'd done the apportionment. And it said the following: provided further that the board may allocate a portion of the actual surplus to be used for former members to a contingency reserve account, which will be used to satisfy the claims of former members, one, who have been identified in subsection 4A, but who cannot be traced. We'll call those the non-traced members, and there was some dispute about this. And secondly, two, who did not substantiate their claim during the nine-month period following the advertisements, et cetera, for data members. So again, here you will see a specific provision that says the board may allocate a portion of the actual surplus to a contingency reserve account. So the power that we've seen so far to establish contingency reserve accounts and the power to take the poor data members' amounts and the untraced member amounts and place them in a contingency reserve account vested in the board on the advice of the evaluator. This becomes very important when we assess the cases. Now, what happened was that the minister can make regulations, and he can make regulations that are not inconsistent with the Act. And those words are very important because the regulations, if a regulation is inconsistent with the Act, then he has exceeded his power and he's acted ultra vires, and that decision becomes invalid. Now, what then happened was that Regulation 35 was passed, I think it was about 2003, if I recall. And what Regulation 35 said, it dealt specifically, first of all, with contingency accounts created at the time of surplus distribution, but then it dealt with what we call the 15B contingency reserve, the untraced former member contingency reserve. It stated that you will place the monies, but basically means create the liability. And what's more, once you've put it in that contingency reserve account, you could not release it unless you paid former member who you found and traced, or alternatively, you paid it to the Guardians Fund, or you transferred it to an unclaimed benefits fund. So you could not do anything with that reserve in terms of unless you paid it out. Now, with contingency reserves, ordinarily, a valuator will assess the value to place on that contingency reserve. And you'll look at a whole lot of factors, the probability of these people ever coming forward and making claims. Will they ever be traced? What tracing exercises have happened? The mortality rates as time goes by. And he will assess the likelihood of that contingency account ever being called on to meet the liability. And if his assessment is, I don't need to hold the full liability because these people will never come forward, he will reduce the amount that he holds in the contingency account. He will reduce that liability. And he will say, I do not need to hold 100%. I can hold 50%. Now, if he does that, then that may potentially release the assets that back that liability. It may not. It all depends on the funding of the fund at the time that you release the contingency reserve. Because, as I say, you're not parking assets in the contingency reserve. You're not keeping assets separate. You're simply looking at the assets of the fund against the liabilities and the contingency reserves. And once you've reduced that contingency reserve, it may reveal that your assets exceed the amount that you hold, in which event you have an actual surplus and it's a future surplus and you do another allocation. However, if your assets have performed poorly and you release some of the reserves, it may all it may do is bring the fund back to a funded position. It may not create a surplus. It may not do anything with it. Now, so what we've seen is that up until now, the board and the evaluator had the power to make that determination. The minister now says you may not do so. Now, a number of lawyers started to form a view that the minister had acted ultra vires and beyond his powers and inconsistent with the act by taking away the power of the board and the evaluator and creating a freeze on the Regulation 35 account. And they argued that either it was an excess of power and an infringement of the promotion of the PAJA, the Promotion of Administrative Justice Act, or alternatively, it was illegal, it infringed the principle of legality, or alternatively, that it was irrational. It was irrational to hold 100% of the fund of the liability if the people were never going to be found and paid. The first challenge that was brought to this was by Mr. Mostert, and he brought a case in terms of which he challenged the validity of Regulation 35(4). That was heard by the High Court. And if you bring a claim in terms of PAJA, you've got to bring your claim within 180 days of the legislation or act that you complain of. Now, by the time all of us brought our claims, a long period of time had passed since 2003. So Moster's case got lost on the grounds that he was outside the 180-day time period and the court deemed it inappropriate to grant condemnation. So he wasn't heard on the basis of PAJA in the 180 days. But the court went further and did an analysis of the law. And its conclusion was that if you look at the Section 15B wording, where I said to you, the board can create a contingency account to house the amounts that can be paid to untraced former members, that should be paid to untraced former members, and the amount that you can house to do the poor data members. The court said that that 15B5E account was only for poor data members. It did not deal with untraced former members. And as such, the Regulation 35 was not inconsistent with 15B because it dealt with untraced members. 15B dealt with poor data members. So there was no inconsistency in the legislation. And they said, even if we granted condemnation, we would not rule in your favor. In the meantime, while Mostert was busy, there were 3 funds that submitted valuations based on legal advice and opinions obtained from senior counsel that Regulation 35 was invalid, where they sought to release funds from the contingency reserves. All of those were rejected, obviously, on the grounds that Regulation 35 precluded the registrar from approving any evaluation that sought to infringe Regulation 35. And that was then the source of the contest for the Southern Sun matter, the Vrystaat matter, and the Hortus matter. All of them were heard, obviously, first in the High Court, and all of them were lost in the High Court. In the Southern Sun case, the court condoned the 180-day period and said this is a matter of substantial interest for the public, and it was in the interest of the public that condonation be granted. So it went on to hear the matter directly on the merits. Even though it lost on the merits, as did the other two funds, when it went to the Supreme Court of Appeal on appeal, because condonation had been granted, it fell to be determined exclusively on the merits, and it was agreed with the minister and with the FSCA that the matter would be argued purely on the merits. And a bench was constituted, a very, very strong Supreme Court of Appeal bench, led by Judge Nafsa. And Nafsa is the one judge that we've encountered in pension law that really seems to understand pension law, and he really seems to like it. It seems to be a sort of interest or a hobby of his, and he really engages with the issues. He's quite interesting to watch because in the court he engaged extensively with the counsel, and it was quite clear he knew what valuators were talking about, which is quite remarkable because very few people do understand them at all. But he clearly was on top of the issue, and he really, really understood it. And he wrote the judgment ultimately. And the conclusion that he reached, having done this entire analysis that I've already done for you, was his conclusion was that the Section 15B(5)(e) contingency reserve was intended to deal with both untraced former members as well as poor data members. So the power to create the reserve for untraced members and for poor data members lay with the board on the advice of the valuator. The definitions of contingency account in the definition section gave it to the board and the valuator. The definition of actuarial surplus again referred to contingency account established by the board on the advice of the valuator. And he basically said the minister had acted inconsistently by depriving the board and the valuator of the power to determine the value to be placed on that contingency reserve. And as such, he had acted beyond his powers, and he had acted out of vires, and the regulation felt to be set aside. So it's got a very important consequence, because what it basically means now is that the power to determine the value to place on that contingency reserve falls back on the board and the valuator. You are not precluded from putting, a valuator is not precluded from putting a value on that he believes represents the contingent liability to the former members who may come forward in the future to make the claim. So it essentially means you can release the value that you put on that contingency reserve, and that may, as I say, have the effect of releasing assets when you do your next valuation, because you've reduced the amount that you're creating as a liability. If you were 100% matched before, it will have the effect of creating future, of releasing assets. That will be future surplus, and that would fall to be distributed in terms of 15C, either to a former member account or to an employer surplus account. Alternatively, if you were a fund that for whatever reason was underfunded at the time or underfunded at your next valuation, the reduction in that contingency reserve may only serve to bring you back up to a funded position. It won't create an additional surplus and no further distribution. That is the consequence of it. Now, there was an argument about whether the regulation should be struck down immediately, or whether there should be time built in for it to be taken out or remedied. And the FSCA argued that there would be substantial prejudice if funds were immediately allowed to release these contingency reserves. There may be abuse. no efforts would be made to trace former members. And the court basically said, all of that can be dealt with because the FSCA has the power to disallow a contingency reserve or disallow the amount created for contingency reserve. So because of that, it said there's sufficient power and we're striking it down immediately. Now, it's in the exercise of that power that the guidance note has been put out. And I'm now going to leave it to Michael to talk to the guidance note.
Thank you, Graham. I'm just going to try and share my screen quickly. I trust it's available now. Okay, so what I'll do is I'll talk quickly just about the Guidance Note 2 of 2020 and what it says and what are all the principles included in that guidance note. I'll then just try and give an example as to what the things are that Board of Trustees and other evaluators could consider in determining a suitable value for the actual value of the contingency reserve. And then I'll also deal with...
Michael?
Sorry?
Yes. I don't think your screen's visible to everybody.
Okay, let me just try again. Is that available now?
There we go. It's come up now.
Thank you.
Okay, there we go.
Okay, so I'll talk about the ways that and factors that evaluators can take into account in setting up a suitable value for the actual value of the contingency reserve, and then I'll also deal with some of the questions that Board of Trustees would have to be able to answer to the satisfaction of the FSCA if they want the actual valuation to be accepted by the FSCA. Okay, so just a few of the paragraphs in the FSCA Guidance Note 2 of 2020. It says that if a board should part with assets underlying these obligations be released, it must be done in a prudent manner that does not inter alia affect the future solvency of a fund. So it's not about the solvency just of the fund at that point in time, it's also about looking at the future solvency of the fund. So there's obviously a big concern that actuaries would be would underestimate the number of members that would one day come forward, and then the fund would be in a deficit position if more benefits are paid than what is being assumed in the actual valuation. It also talks about the FSCA's expectations of what would constitute ethical, prudent, and responsible practices by a fund. So the board would certainly need to justify their actions in this regard or in line with that. And then the purpose of the guidelines are as necessary safeguards to ensure that boards act in a way that the fund does not prejudice former members. So there's certainly some consideration about that funds would be trying to either enhance benefits or protect the benefits of current members at the risk of former members. That has to be addressed. So getting to section 3.7 of the Guidance Note 2 of 2020, the first two sections or paragraphs talk about how a valuation basis can be set. So first of all, the board should be able to illustrate all the steps taken to identify and trace former members. And it talks about not just what the board did perhaps 15 or 20 years ago when the surplus apportionment scheme was approved by the FSB, but also about what it has done up to the point in time when the valuation report is being submitted. So boards would have to be able to demonstrate that they have not just performed a few tracing exercises in the beginning and not try to revive them and find new tracing agents and make use of new tracing agents afterwards. So boards certainly have to demonstrate that they have done all what is reasonable to try and find these former members and make payment to them. And then the evaluator must, or the board actually must be able to motivate the assumptions used in determining the assets to be held. So it's very important that when the evaluator determines the assumptions to determine the actual value of the liability for these former members, that the evaluator take into account all the steps that the board has taken, and that this will form part of the history and the motivating factors that the evaluator would use. So some of the things the evaluator would be able to take into account of, and Graham has already talked to some of these is, first of all, you can look at the quality of the data set. So in my experience, I've had a few surplus schemes where the fund was administered by different administrators and in different periods of time from 1980 onwards, and the quality has certainly been very different when you try to build all these databases of the former members. So in some cases you would have very old data with members but without any ID numbers, so they certainly become more difficult to trace, and that can be taken into account into determining the probability of the fund being able to trace these former members and make payment. Another factor would be to consider the duration since the exit of that former member. So obviously, if you have a scheme where you've included former members since 1980, if the member exited the fund at 1980, it is probably less likely that you would be able to find the member and make payment to the member than if the member exited in 2001. So I would certainly look at that as well. Another factor to consider is the nominal value of the benefits. And this doesn't mean that the Board of Trustees are only going to try and trace members with higher benefits due and forget about members with smaller benefits, but it is a fact that if a member is due a very small amount, it's going to be a lot more difficult to actually get that member to submit the claim forms and to receive that benefit. If you have been able to find the member and trace the member, and the member saying, well, you know, submitting all these claim forms is just not worth the effort, it doesn't mean that the liability goes away, but it does mean that you are not going to be able to pay this benefit out to the former member. And then the fourth one I've dotted down is the probability of a former member still being alive. So if a member has passed away after surplus apportionment date, it doesn't mean that the liability is gone or that the fund no longer needs to pay that allocation to the former member's beneficiaries. But what it does mean is that if you are having difficulty trying to trace a member that is still alive, trying to trace the beneficiaries of a deceased former member is going to be even more difficult. So that is also something the Board of Trustees can take into account. Or sorry, the valuator can take into account. So just to have a very simple example, so you could, for example, have a valuation basis where you say the actual value of the liability is equal to the full face value of the liability multiplied by 2 factors. And the one factor could be the probability of the member still being alive. So again, you could be a function of that. So you could have, 50% multiplied by the probability of the member still being alive. And then another factor would be a duration-based factor where you would say, for example, for every year after surplus apportionment, for a member that's due a benefit above 10,000 Rand, the probability of finding that member diminishes by 2% on a geometric basis every year. And if the benefit is smaller, then the probability of finding that member reduces by even a greater extent. And then you can have an overall assumption. So I would, for example, not want to have this run down forever and a day. I would have a limit. I would consider to have a limit on the face value of the limit on the actual value of the liability. So for example, after you've applied this formula, if the value of the liability is less than 50% of the face value of the liability, you would limit it to 50%, so that you still keep some level of assets available. But it will ultimately be something the evaluator need to discuss with the Board of Trustees. You have to look at your own experience, the experience of being able to trace members and pay them, and then you would have to be able to justify this to the authority. So just in terms of the practicality of what will happen, so let's say you have a fund at the start with an active member liability of 100 million Rand and the face value of your unpaid surplus allocations of another 100 million Rand. Your assets were 200 million Rand. That would mean that you have a 100% funding level at the point of time when you have the actual value of the liability equal to the full face value of the liability. So let's say after you've applied all of your assumptions, you determine that the actual value of the liability should only be 60 million Rand, then you would be releasing 40 million Rand as a new Section 15C surplus. The important part is to remember that the full obligation will always remain, so that is not in question. You are not reducing the benefits, you are simply reducing the value of assets that you keep behind to service these liabilities into the future. So the important part that some of the questions the FSCA would be asking and the Board of Trustees would have to justify is how it would be using this new Section 15C surplus. And I think there can be a lot of many difficult questions that the boards would have to justify. And it would be even more difficult if the fund was in surplus, or sorry, not in a deficit at the start of allowing for this actual value of liabilities. So assuming, let's say the fund was not in a deficit, then the first thing is the board would have to motivate why allocating surplus to one stakeholder at the expense or the risk of another is justified. So there is certainly the concern that if you do allow for this valuation basis, that you would be reducing the value of assets, backing the liability of these former members. And why are you doing that? You are in a way putting them at risk if there are more of these former members that would come forward than you expected. And you would have to justify why you are benefiting one stakeholder at the potential expense of another. If you are improving benefits, for example, if you are using that to fund your pensions account, you would also have to motivate why it is necessary for you to improve the benefits of one group of members and exposing another group of members at valuation risk. If you would be allocating this to an employer surplus account and the fund was not in a deficit, it would be even more difficult to try and justify why you would want to benefit an employer at the expense of a valuation risk of former members to whom the Board of Trustees have already allocated these benefits. If a fund is in a deficit, I believe it is slightly different. I'm not saying that the questions are not going to be as pertinent and as difficult to answer, but ultimately what a Board of Trustees have to do, and it was pointed out in the guidance note by the FSCA that the fiduciary duties of the Board of Trustees are in respect of benefits to be paid to members. So that would include these former surplus benefits payable to members, but they also have a fiduciary duty in terms of the fund and ensuring the financial solvency of the fund. So I certainly believe that when a fund is in a deficit and you are having a fund where there is no employer that can be called upon to make good of the deficit, if it's, for example, a defined contribution fund that for whatever reason got into a deficit, it is different, because then you have to weigh up two things that you have to try and balance different interests of current members as well as former members. You are not trying to improve the benefits of one group of members at the expense of another. So if it's in a deficit, it is slightly different questions that you would have to be able to consider and justify. If I then move to section or paragraph 3.7c of the guidance note, this is where the FSCA has expressed their concern that there's a risk that the assets retained will be insufficient and that boards should therefore provide for the manner in which the liability will be met, which should be reflected in the rules of the fund. So in other words, the FSCA would want to understand what will be the plan of the fund if the fund is in the future not financially sound, and if more former members are coming forward than what has been allowed for. So there are, in my mind, a few possible scenarios. I'm not saying that this will meet the requirements of the FSCA. It's just some of the things that I can think of. So one would be, for example, if you used this release of assets to benefit a pensions account, the assets could still be within that pensions account, and you could possibly write into the rules that if there's a shortfall or any into the future, that it would be funded from a pensions account. So that would mean that there is still the assets remaining behind for these former members, and that you can call upon from the party or the group of members that have benefited from this action. But then you would also face some questions about treating your different cohorts of pensioners fairly. So it might then also mean that your existing pensioners are going to benefit from this, and your future pensioners are going to have to fund a deficit, and so you would have to be prepared to consider that aspect as well. Another one would be if the surplus was released to the benefit of the employer, or for example reduce a deficit that the employer had to fund, and the employer then underwrite this valuation risk. But then you would also need to consider what is the credit risk of the employer, and whether it's fair to expose these former members to the credit risk of the employer paying for this deficit, if there would be a deficit into the future. So that's also a possible scenario. I don't know whether the FSCA would then want to see that there is a funding asset by the employer set aside for this potential credit risk scenario, but it is something that would probably be something you can consider. The last section of the guidance note is 3.7D, and I think this is actually a really problematic issue that boards of trustees will have great difficulty dealing with. And what this is about is that the FSCA is concerned that if a fund would one day want to transfer all these unclaimed benefits to another unclaimed benefit fund or a centralized unclaimed benefit fund, then the fund would not have sufficient assets to do so. And the unclaimed benefits fund would certainly, well, most probably, but from my own experience, I know that this to be true. The unclaimed benefits fund is not going to accept less assets than what the face value of these liabilities would be. So then the board should, in such an event, indicate its plan of action at the time of submitting the valuation report, how they will be dealing with this. So I'm not sure what a suitable plan of action would be here. Again, you could have, for example, assets set aside in a trust by an employer to fund any such deficits if the fund would one day get to the point of liquidation or deregistration. Deirdre is also going to talk about some of the impacts of the Kochi bill. So there are draft legislation on the centralized unclaimed benefit fund and some of the consequences on liquidation that would be changing with the Kochi bill that trustees would also need to take into account. So certainly it will become extremely difficult to get to a point of liquidating or deregistering a fund if the board of trustees have decided to place an actual value on this liability that is less than the face value of the liability. So with that, I'll give over to Deirdre to discuss the Kochi bill.
Thank you, Michael and Graham. Just want to see, can everybody see my video? Michael, if you maybe want to close your slides.
I'll just give me a second.
So yes, it's a very interesting debate, various questions being posed in the chat. I must admit, I don't think we all have the answers to these yet, but just in relation to Kochi, as we all know, and some of the problems that will arise is that we have the centralized unclaimed benefit fund, not yet being proposed, and then we have our ordinary unclaimed benefit funds. Now, some of the questions are, what happens if these assets then are unclaimed benefits and it is impossible to trace and it's impossible to pay? And for example, the fund is not doing a 15C distribution, or the fund is nearing liquidation. The only liability is this liability that is left. What should funds be doing? Now, should Kochi come in as currently worded, there's two potential problems, and I think it's going to be practically impossible to implement, is that there's a proposed amendment to 37A where a section will be introduced that says the unclaimed benefits may not be reduced in any other way. We don't know what other way means, and the questions is, can these unclaimed benefits then be reduced at all? Why is there a proposed amendment that unclaimed benefits can't be reduced? Bearing in mind that there's many fund rules that have been approved by the FSCA that says reasonable tracing costs and those things can be deducted from the unclaimed benefit. Another thing we need to take into account, and again, we don't have answers to these yet, and Kofi still being in bill form, is that when you go and look at section 28 of the proposed amendments to the Pension Funds Act, it now currently, it says that, on liquidation, liquidators various powers and may pay assets to or unclaimed benefits to a guardian's fund or an unclaimed benefit fund. One of the proposed amendments to section 28 is that if it remains unclaimed for 6 months, then the liquidator must pay it to a unclaimed benefit fund or to a guardian's fund. Nothing is mentioned about the central unclaimed benefit funds. So those are some of the practical issues, what are funds going to do with these benefits that we, it's a movie to be watched. We don't know what's going to happen yet. So I just want to go through some of the questions that have been posed. One of the questions were, Graham, I don't know if you want to answer these, or Michael, how often what will be regarded as you've completed the searches now? So now that the FSCA has said that tracing exercises need to take place again, what will be regarded as a sufficient tracing exercise? How far do you need to go for the FSCA to be deeming that as a proper exercise?
Michael, do you want to give it a shot, or do you want me to?
So from a legal point of view, I'll rather have you answering, but I can just think of if I was involved in a board of trustees, the important part is it's the board of trustees that have to justify it. It's not, the board of trustees have to consider what they deem to be reasonable. So that means the board of trustees can consider, doing certain tracing exercises over a period of time, trying to find different tracing agents. And at some point in time, you can certainly see with any tracing exercise that they have this diminishing results where you have less and less and less former members being successfully traced every time. And once the economic cost of trying to trace these former members outweigh the benefits that you are paying to the members, you probably have a basis of justifying that you have tried what is reasonable and fair.
But yeah, I think the important part is it says you can't rely on historic and outdated tracing exercises. So you can't go back to the original tracing exercise that you did back in the old 2001 surplus apportionment days. You would have to show ongoing efforts to have traced over this period so that you were live with your tracing efforts throughout the period, or alternatively, some form of new tracing exercise. So I think that's what's going to be required.
Thank you. Another question that has been posed, maybe it should be directed to you, Michael, if you want, is in one of your slides, you mentioned that it may be problematic if funds then were to distribute to an employer surplus account. What happens then if the rules of the fund currently provides that future surplus is permitted to go to the employer surplus account, i.e. what the fund intends to do is permitted by the current rules? Will the FSCA still see an issue with that?
So obviously I can't speak on behalf of the FSCA, but the point that I'm trying to make is that Board of Trustees must be prepared to consider and justifying the basis of their actions. And if a fund is not in a deficit and this is allocated to employee surplus account, then you have to consider, so why are you doing this? Are you doing this for the benefit of the employer at the risk of former members? And how do you justify this? So a potential justification, I'm not saying it's impossible, but a potential justification could be that the employer has agreed to, put aside all the monies made use in this allocation for an employer contribution holiday, and then put aside an equal amount of money in a trust account for every day that if there would ever be a shortfall, or if the fund needs to be liquidated at some point in time in the future, and there needs to be a top-up in order to transfer the full face value of these liabilities to a new unclaimed benefits fund. But in that same vein, then I'll ask, if I was the authority, I'll ask the question. So, you know, why are you doing this? What are you achieving? Are you achieving anything real in doing this? And that's why I'm trying to make a point that, you know, if the board of trustees, if the fund is in a deficit and the deficit can't be funded from any other sources, then it becomes a little bit different question to answer. And then this is potentially something that the board of trustees can consider more strongly.
Perfect. And it's just one thing to remember, that these guidance notes isn't law. So I'm not saying that it should be disregarded. This is clearly the FECA's expectations, but it's not a directive in how to deal with this. It's not you know, some type of interpretation ruling. It's merely a guidance note expressing the FECA's views. So it's still to be tested what's going to happen here. One of the other questions is, and again, I don't know if this is an unfair question to pose to Michael. Can the board establish a contingency reserve less than 100% for unclaimed benefits unrelated to surplus distribution on the same principles?
I think that's very easy. That this is a legal question, and this whole legal issue is certainly only about surplus benefits. So it doesn't talk at all about other unclaimed benefits. I'm not saying that it's not, you cannot see that it's practically something that can be explored, but there is no opinion expressed here about other normal unclaimed benefits. Specific
to the contingency reserve account and how that arose. You know, it's attached to that case and the issues that was before the case, before the court. I don't know. I mean, there's several questions, very long questions that have been posed here. I think what we will be making the slides and this recording available. Two, we will think about, I just need to check with the PLA whether we can consolidate these questions. So that, and that's one of the questions that was asked, why can't we see the questions of the panelists so that we can share everybody's thoughts with some of these very difficult questions. I see we have, I thought we would run out of time. We have another 10 minutes. So I'm going to ask another question. Feel free to decline to answer from a risk point of view, Graham or Michael. But a question was posed, is the considered view that these benefits represent a liability? If that is the view, then the money should never be in a CRA, in a contingency reserve account, but simply unclaimed.
I think it's the same point that Jonathan Mort was making. I saw his comment regarding the fact that it should not be treated as a liability, full stop. Why is it being put into a contingency reserve account in the first place? I think the reason why it's being put in a contingency reserve account is that 15B5E specifically stated and conferred a power on the board to place it in a contingency reserve account specific for that purpose. And of course, we had Regulation 35, which said you must. So that's what we've historically been doing all along, because 15BE, 5E and 35 said we ought to. Whether we should going forward is obviously a different debate. And I'm not an actuary, so I don't know whether you would stick it as a liability or as a contingent liability.
Thank you. Can these assets that have been released and the further tracing exercises that the fund, well, that the FECA requires, these fresh tracing exercises, can any of the costs associated to that tracing be deducted from the amounts held in that contingency reserve account? So
the way I read Section 15E E is that it specifically states that when an amount is due to a former member as by way of a top-up, it must be increased by fund return, full stop. There is no provision that says you can deduct any expenses from that. You've got to add fund return. So I don't see an ability to deduct the additional tracing costs from the amount that you owe to that former member and treat it as a deduction.
Okay. So I think, unless there's anything specific, Michael and Graham, you want to close off on, I'm going to end this session. And I thank you everybody for participating. Like I've said, very difficult questions, very interesting questions coming through. I hope that, and I trust that I can see it from some of the comments that Graham and Michael have already answered some of the questions that have been, that came through. So thank you very much. Again, we'll make these slides and the recording available to all of the delegates that have attended. And we will try and consolidate some of these questions that have been posed so that everybody can just see the theme of the questions, not necessarily promising any answers to those questions. Thank you. Graham, Michael, thank you very much. Any concluding comments, but for good luck?
The one thing that I can certainly see with a lot of these questions is that there are many practical issues. So we've now considered what the practical issues are about setting this contingency reserve setting an actual reserving basis that is less than the full face value. But there are lots of issues about, so how do you deal with these things ultimately? I mean, there are practical questions. It's now 20 years later, these unclaimed benefits still need to be administered. So somebody needs to pay for this administration expense. It couldn't have been the purpose when you set out surplus apportionment expense reserve account 20 years ago that, after 20 years, all the unpaid and untraced surplus beneficiaries are still going to be administered out of an expense reserve account. And there are obviously questions about, so what do you do? I saw one question, what do you do if a person has been traced and the person just say, I'm not going to complete the form, it's just too much hassle, I'm not going to do anything. So, what practically happens with that? And there are no answers for that at the moment. And I know that it was not the purpose of this discussion today to answer things like that, but I share the sentiment of a lot of the questions being expressed, that there are so many impractical things that boards of trustees have to consider that there are just no easy answers for.
Yeah, just so my closing remark is that this problem of the unclaimed benefits, particularly for the former members that were part of the surplus apportionment scheme, is a material problem for the industry. It's going to be with us for a very long time. There is a real prospect that these benefits are never going to be paid, that you're going to have this liability on your book and you're going to have to hold these assets in perpetuity. And there's a real risk that that's what we're dealing with. I think we're going to need a legislative intervention that somehow at some point in time, we bring these claims to an end and that this money is freed up to be put back into the economy. But we need something that brings it to an end. Otherwise, as I said, we're going to have this money locked up in perpetuity, and that's not good for the economy. It's not actually good for anybody at all. And it's not good that gets put into a guardians fund or a centralized unclaimed benefit fund where the prospects of ever finding anybody are zero. So I do think at some point in time, we're going to have to relook at this.
Graham, Michael, Jidre, thank you very much. That has been an extraordinarily good presentation. I can see both from the comments and from the number of participants who've stayed online for the full hour, over 240, nobody dropping out virtually. So well done, and thank you very much for your time. Very slick, very professional.
Thank you. Thank you all.
Thank you.
Bye.
Cheers.